Anything? So we'll meet single bench. No?
May it please your Lordship. Lordship, I beg to make a mention of item number 17, your Lordship. Lordship, I pray if this matter may be listed after 2 weeks.
Your Lordship, this matter had been listed before the Chief also on 2 occasions.
But then, why is listed?
Your Lordship, perhaps because the Chief is not here.
Oh, that cannot
Because
be.
service matters as per the roster up to the year 2020 are supposed to be.
That cannot be. If he's not here, doesn't mean that matter has to be
That's what,
taken from his
Your
board.
Lordship, there's confusion as to why it's listed.
Have to check with the registry then. Okay. To play it safe, we'll just post it for pre-made by the petitioner. This is matter up to 2 weeks.
Obliged, Your
I do
Lordship.
oblige, your Lordship.
May it please your Lordship. Your Lordship, I beg to mention item number 23 on behalf of Miss N.G. Shilla. She is indisposed, your Lordship.
20.
23, your Lordship.
Yes, who's for the petitioner?
Mr. P.K. Bora, your Lordship.
Have you got his consent?
I'll inform him, your Lordship. He's not around.
Let it be called up then. In the meantime, you try to seek his
Yes, sir.
consent.
Oblige, your Lordship.
May it please your Lordship. Lordship, I beg to mention item 14. Your Lordship, for respondent number 1 and 2, Mr. P. in his outstation, your Lordship.
2017 matter. I think this court has made it very clear.
Your Lordship, let the matter be taken up on 25th, your Lordship. Thursday.
You are appearing for?
Respondent 1 and 2.
Prayer is made on behalf of the respondent 1 and 2 on the ground that the conducting counsel is indisposed and could not appear for the court today. On prayer made, the same is allowed.
No objection, your Lordship.
On the same not be objected to by the petitioner. Matters adjourned. List the same on 25th. 25th.
Your Lordship, similar prayer for item 16, your Lordship. Yes, your Lordship.
On prayer made by the petitioner, this is matter up to 3 weeks.
Degree
Have
of
you got any?
No, your
confirmation?
Lordship. No instruction, your Lordship.
That is the issue of substitution.
Yes, your Lordship. Oblige, your Lordship.
My Lord, I beg to mention item number 12, my Lord. Praying this matter can be taken up next week, my Lord.
On prayer made by the appellant, this is matter up to 2 weeks.
My Lord, similar prayer for item number 15, my Lord. Yeah, I'm for the respondent.
$15.
My Lord.
No objection.
2020 matter.
My Lord.
See, firstly, it's a revision petition,
My Lord.
and it's more than about 3 years or so. More than 3 years. It's kept pending. What is the issue about?
Actually, it's a revision against the impugned order, which is for grant of ad interim injunction.
Grant of?
Ad interim injunction.
In a suit.
It's basically a land dispute, my Lord.
It's a land dispute.
Land dispute.
Please ensure that it's, otherwise, eventually you'll find that both parties will be losers. cause of justice is lost. Wait, how long?
After a week.
1 week.
On payment by the respondent, not objected to by petitioner. This is not up to 1 week.
My appeal is Lordship. Lordship, I beg to mention item number 24, Lordship. I pray for 3 weeks' time, Lordship.
You are for?
I will respond, Lordship.
Yes, for cancellation of bill.
Yes, Your Lordship.
On payment by the respondent, not objected to by petitioner. This is matter to 2 weeks.
May I please, Your Lordship? Your Lordship, I beg to mention item number 20, Your Lordship.
20. Cancellation of bill. You are for petitioner.
Yes, Your
What
Lordship.
is this matter about?
Cancellation of bail, same matter.
Cancellation of bill?
No, is it Basham? No, it's regarding
Promotion.
promotion also. Sorry, I thought the other one. Promotion.
Or payment by petitioner, this is matter to 2 weeks.
May I mention item 11, my lord, for next week. My lord, here,
11 is?
11,
Acha,
praying for this listing of this matter next week, my lord.
Why?
Again, my lord, this matter, Mr. Paul is leading us. He is not there in town today, my lord. He is not available due to some slight preoccupation, my lord. He'll be there next week, after this week, my lord.
See, this is also a very old matter.
Correct. That issue.
I think it was stalled all along because of the one of the parties not being.
Yes.
sorry, Lordship. We've tried it. We have tried many times to dispose of
Now
it.
everyone is on board.
Yes.
I mean, Darbar Strong is still not on board, my lord. In spite of receipt of service,
Then
they've
spite of
chosen
receipt
not
of
to,
notice, they have
not to appear. Yes,
Then, we
But
proceed
other laws
if-
all on board, so we can proceed if Mr. Paul is here.
on payment by petitioner. Seeking adjournment on the ground that the Learned Senior Counsel, Mr. A. Paul, is indisposed. Matters adjourned. This is the after 2 weeks.
Daily list item number 1.
Please, Lordship. This is the application for grant of anticipatory bail. Wait, please, Lordship.
Take it. You be there. I know. Yeah, thanks. What is the something what?
Yes, for item number. Hey, please, Lordship. Lordship, here, my lord, we are before this honorable court for grant of anticipatory bail to the petitioner, pursuant to, my lord, an incident which happened on 16th of March this year in Ampati, my lord. The background, my lord, what had happened is, on 15th, my lord, 15th was the last day before the model code of conduct came into place. So from the 16th, the model code of conduct had come into place. So on the 15th, my lord, there was a party meeting of the various parties, and they were campaigning at still that point of time, my lord. Now, in this case, what has happened, my lord, if Lordship is pleased to come to page 10 at paragraph 7. Lordship has paragraph 7 at page 10.
Paragraph 7.
If I may just read, my lord. That on 15th March 2024, before the commencement of the Model Code of Conduct, in the daytime, a party meeting of the NPP was held at Cherangri, Southwest Garo Hills, near Ampati, my lord. Petitioner, along with others, had gone to the said party meeting so as to support the brother's party candidate for the upcoming election. Now, the petitioner's brother is my lord, the former MDC from NPP, from Boldamgri, one Mr. Stevie Marak. So they had gone along with the brother, my lord, for the party meeting. Thereafter, my lord, lordship will see, after the party meeting was concluded, these people, my lord, they travelled to Ampati to attend a wedding. That wedding, my lord, got over at around 10 to 11 o'clock. Thereafter, they left for their respective residences in a carpool sort of system, my lord. Now, on the way, my lord, near this, there's a petrol pump near, more or less near the Assam Meghalaya border, my lord, that is called Gandhipara Junction. There, my lord, on the midnight of 16th, on the next day, these people, they stopped for having tea and all, my lord. And in the meantime, a scuffle broke out between two parties. Appears to be, my lord, that because of a political, some from TMC, some from NPP, because of that reason, there was a scuffle. Little bit of, my lord, vandalism also occurred. Thereafter, my lord, lordship, thereafter the parties left, and on 19th, my lord, an FIR was lodged before the Garobada outpost. Lordship will kindly have that FIR at page 24.
Yes.
Lordship, page 24. To the in charge, Garuda OGC. This was lodged on 16th, received on 19th. I'm sorry. With due respect and humble submission, I would like to report to you that on 16th March 2024, I, so-and-so, son of so-and-so, along with so-and-so, son of so-and-so, of village Barkona under Makhachar PS in the South Salmara Makhachar, Assam, we are proceeding towards Tura Civil Hospital from Baghapara by Marindra Bolero, white registration number so-and-so. On reaching Kathalbari Gandhipara Junction at about 12:30 am, the driver named so-and-so went to toilet to evacuate, and in the meantime, one white color Bolero, an unknown four-wheeler, suddenly stopped in front of our Mahindra Bolero, and namely Silchang CH Marak, inhabitant of so-and-so, along with his 7-8 number of friends, came out from their respective four-wheelers and started to assault me inhumanly while I was sitting inside the Mahindra Bolero and received grievous injuries. Silchang Marang dragged me inside the vehicle and set fire into my vehicle with an intention to kill me, but fortunately, for the sake of my life, I somehow unlocked the door and crawled down from my vehicle, screaming out in pain, and fled the spot. So here, my lord, one person has been named, one Mr. Silchang CH Marak. He has been clearly named that he is the one who has apparently, my lord, dragged him inside the vehicle and tried to set the vehicle on fire. And however, my lord, this petitioner herein comes in this 7 to 8 number of friends who are also there. So at this stage, my lord, I humbly pray that, my lord, the interim protection may be granted, because on last Saturday itself, last Saturday as well, right from the time of the FIR, they have been, my lord, searching. They are also calling the petitioner's brother as well as other persons as well as the petitioner. And as late as on last Saturday, 13th, my lord, also they had come to the residence of the petitioner, he who was staying along with his former MDC brother. So in that view of my humble submission is, my lord, that these petitioners, the petitioner here, did not have any intention to indulge in any such offence. He had only gone to support his brother, my lord. Thereafter, he went to the wedding. They were coming back together, and some incident happened, my lord. It appears to be because of some political, but that will come out in the course of investigation. At this stage, my lord, I humbly pray that since the petitioner, my lord, is not having any criminal antecedents, he is about 28 years old. He is just a petty contractor, my lord, permanent resident of the Southwest Garo Hills. Interim protection may be granted, my lord. We will cooperate with the IO immediately, and lordship may call for the case record in the meantime. Silchang Marak has been arrested. The person named in the FIR has been arrested.
Yes. Lordship 307, grievous injury. Vehicle was set into fire. And admittedly, he made a submission that they were present along with the group, except the one person was named in the FIR. Matter is very serious, Lordship. So at least interim may not be called for at this stage. We'll call for the case diary and see what is how are they involved.
Strict conditions may be imposed.
Grievous injury is the vehicle being burned is very, very serious offence, Lordship.
Yes, true.
Because the named accused also was initially granted interim bail by the learned trial court. Thereafter, it was rejected on the final date. So he has been arrested on the same date.
All the more reason.
There must have been reasons why it was
Absolutely.
rejected.
Because that order is there, my lord. Lordship will kindly have it page 28. Lordship will see heard towards the bottom, my lord. Heard both parties and also perused the report. IO has reflected in the report that he requires petitioner accused to be arrested for the purpose of investigation. Also that petitioner accused contradicts his statement with findings of the technical analysis. I have perused the report. They are incriminating materials against the petitioner accused person, and IO requires his custody for thorough investigation. So on this ground, my lord, the bail was rejected.
This is an order against the petitioner?
No, not the petitioner herein, the named accused, my lord, Silchang. Yes. I may pray, my lord, matter may be fixed next week only. We will, for that time, because if he is implicated, my lord, because he is not at all involved in the offence, it will be a grave stigma to him, my lord. We'll go and cooperate to tomorrow itself, my lord, through the IO.
It's not about cooperation, it's election time. As I submitted, the vehicle being burned, they were present and bail being rejected. It shakes normally the conscience of the society and such grave comments around it. So granting anticipatory bail, especially when the main accused is rejected. We'll wait and see the case diary, Lordship. What is
The
it?
case diary has to be perused.
Till then, my lord, the interim is granted, my
We
lord.
don't know what is the stage of investigation,
Absolutely,
how is the
absolutely.
progress,
We'll try to get
what
the-
the process employed, all those things have to be.
Till then, I am pray the interim protection will be granted, because otherwise sometimes they are arrested also, my lord, and the matter
I
becomes
will,
infructuous
Lordship, I
also.
will just oppose interim at this stage may not be called for because considering the nature of incident which shocks the conscience, Lordship.
Just from southwest, my lord, some time will be required also for the
It's okay.
perhaps.
It's okay in any case.
Heard Mr. Esdeep, learned counsel for the petitioner, who has submitted that on the basis of an FIR dated
Dated 16th.
16/3/2024, lodged before the in charge Garubada OCG, capital no itu O.G.C, Southwest Garu Hills. The informant therein making a complaint to the police with regard to an incident which allegedly took place on when was
Also, that was at 12:30 a.m. on 16th itself, midnight. my lord.
it took place at 12:30 a.m. on the same day, involving assault and vandalism of a vehicle. The FIR being registered as
Ampati PS case 27/3 of 2024.
Ampati PS case.
Lordship will find that at page 7, my lord, in the cause title.
So I get over Ampati PS case number 27/3 of 2024 under section to spec animal. Kata pun yang tu the last line over. The investigation launch into the case. The investigation launch has also implicated the petitioner herein, who admittedly was present at the scene, but has pleaded non-involvement as far as the incident is concerned. It is this apprehension that has compelled the petitioner to approach this court with this application under section 438 seeking grant of pre-arrest bail. Before proceeding with the merits of the case, the Learned Counsel has, however, submitted that it would be prudent for this court to call for the case diary of the said Ampati PS case, Advocate Supra. In the meantime, it is also prayed that the petitioner may be allowed interim bail. Per contra, Mr. K. Khan Leonard PP has submitted that the offence involved would reveal that the case is one of a serious nature involving assault and also an attempt to murder. Therefore, even though there is no objection for the case diary to be produced, the prayer for interim bail is, however, objected to. This court, upon hearing the parties and on perusal of the petition, would agree that the case diary is required to be looked into, since the matter is apparently, since the case is apparently under investigation. This being the case, the prosecution is directed to produce the copy of the case diary on the next date fix. As for the prayer for interim bail, the prayer made is allowed. The petitioner is, however, directed not to abscond or to tamper with the evidence and witnesses, and to appear before the IO as and when required. Place this matter on. When do you?
At least 10 days South Ampati in election time, Lordship, please. Kani.
Election is over now.
I know, but Lordship, they always. We'll try to get as soon as possible, Lordship. We'll try.
So you suggest that it.
Lordship, any 10 days from today?
When will that be?
22 second.
Okay. First. We'll fix it on first then.
First May.
Fix this matter on first May.
Oblige.
Same Lordship, the next item also is the same matter. Same arranging of the same affair. Same order.
Same order.
Right. Much
Item
obliged.
number 3.
Yes.
It please your Lordship, this is an application under 439 Malad for grant of bail. The grounds that the petitioner herein is seeking to urge before your Lordship is the protected incarceration. He's been in jail for more than 6 years now, pending trial, Malad. And as your Lordship is aware that, Malad, prolonged incarceration pending trial is something which amounts to inflicting pre-trial punishment, which is not permissible, Malad.
See, you, as far as the incarceration period is concerned, you measure that in terms of the punishment that that would have been given had the
In other words, seriousness of the charge, my lord.
So what would be? Is it life or 10 or 20?
One of these sections are life. The minimum is 10 years, my lord. He has already suffered more than 6 years. But those are all subject to prove, my lord. As your lordship is aware that he is presumed to be innocent unless found guilty by the trial court or by the competent court. My lord, the only difficulty here is if this gentleman is continue to be in jail and tomorrow if he is acquitted, my lord, the law is as such that he can't even go for compensation. And no,
Mr. Thapa,
my lord.
that is the legacy that we have inherited.
Inherited. My lord.
Bail jurisprudence is such criminal, law or criminal.
In fact, my lord, the other reason why I'm before your lordship is, my lord, I'm equipped with your lordship's last order, where my lord, your lordship has made it clear that in the event the trial does not complete within the in the next preceding year, my lord, I may make an application for bail.
Even otherwise, you can apply for bail anytime.
Correct.
There's one slight problem here, my lord. My learned friend has come before the wrong forum. Well, this trial is conducted before the special NIA court. Now, any order of the NIA court has to be challenged before the special division bench of the Honorable High Court.
I was about to ask.
Division bench of the Honorable High Court has already rejected the bail, and my lord, given them the liberty to press for further bail if you are not able to complete trial within the last year. My lord, we were not. I mean, I concede that we were not able to complete the trial owing to that problem in Manipur. My lord, a lot of our witnesses are from Manipur. Now, my lord, my learned friend can only go back to the trial court first and thereafter come back before the division bench. My lord, my submission before this honorable court is this court does not have the jurisdiction to entertain a bail application under 439 in a trial conducted by a special court, my lord.
No, your lordship, I slightly beg to differ with this proposition. Why I'm saying this is, lordship, insofar as bail under NIA, under UAPA Act is concerned, my lord, the provisions of bail is still governed by the CRPC. So even if you go before the special court, my lord, we have to move under 439. Now, your lordship is aware, insofar as 439 is concerned, it's a concurrent jurisdiction. My lord, there's nothing under the NIA Act, my lord, which puts a restriction on your lordship to exercise its power under 439. Insofar as section 21 of the NIA Act is concerned, my lord, we can approach the division bench only when we assail an order of the trial court. Now, in this particular case, we are not assailing any order. So, in that view of the matter, my lord, your lordship has jurisdiction to entertain this application under 439.
Well, I slightly beg to differ, my lord. The fact is, my lord, the first bail application was moved before the special court, subsequent to which they came before the division bench. Now, my lord, division bench is on appeal under section 21. That is the only provision when in under the NIA Act. Now, my lord, when the division bench has rejected the bail application of my learned friend, my lord, how can my learned friend come before the single bench under 439? My lord,
No, because my lord may kindly see the order.
As Mr. Thapa has rightly pointed out, the matter before the division bench
was an appeal.
Could be rising out of the bail order. That is, acceptable.
Well, what he's submitting is that, my lord, he has approached this court under original jurisdiction, my lord.
Yes.
But then, my lord, in that case, let this matter come up after 2 days, my lord, because I'll have to seek some instructions. Of course, what he's saying also in a way is correct. But then in all the judgments which I've come across, my lord, in fact, on the last occasion also, lordship will remember, a similar application was filed before this honorable court, with this single bench. But I place a judgment of the Supreme Court, my lord, where it's very clear that but in that case, of course, there was an appeal against an order rejecting bail.
So, insofar as appeal is concerned, my lord, I have no...
We will confine ourselves only as regard the original
jurisdiction.
Exactly.
Correct.
bail jurisdiction.
Correct, my lord.
Whether this court does have that. Otherwise, it's pointless.
Yes. And there's no, my lord, the entire act...
There is a provision in the act that you have to appear before the trial court, the special court, or even sessions court for that matter, if there's no designated special court.
But he has placed a very interesting argument. In fact, my lord, there is some grey area over here because here we only talk about appeal. But my lord, my submission there is, my lord, once he has exhausted the remedy before the special court and he has come before the division bench, my lord, those orders have merged. Now he cannot say that I have never been to the special court.
No, I have not said
that. That would create a very different kind of my lord,
no, I have not said that, my lord.
That
order, my lord, the order of the trial court earlier, my lord, it has already merged with the division bench order and hence it has attained finality. Now, there is no question of further challenge to that order.
Yes. You satisfy this court first on jurisdiction.
My lord, if my learned friend is saying that he will please some judgment, let him please the judgment.
Let me
If
give
the
it 2
law
days,
says
my lord.
if the law says otherwise, then we have to bind. We
Exactly.
have to obey.
On pre-made by the parties, list this matter on 24th.
Always.
Obliged.
Item number 4.
May it please, Lordship. Lordship,
For my land friend Star, Lordship, the charge sheet is incomplete, Lordship. Copy of the charge sheet is incomplete. Charge sheet
What
is
is this matter
incomplete.
about?
this is basically, my lord, we had filed an application under 227 before the learned session judge, my lord, wherein my application has been rejected, my lord, on the ground that, my lord, there is a prima facie evidence wherein, my lord, my CDR shows that even my involvement, my lord, in the alleged offence, my lord, wherein, my lord, the matter of in the instant case, my lord, there is no piece of evidence, not even CDR, neither, my lord, any of the witnesses has taken my name to
Now
rope
you're
in.
going. Now you're going to the merits.
My lord, my lord.
Mr. Kharmi says that some of the
Case
documents are not.
is incomplete. Page 53, Lordship. Page 53. Some more pages are there. Missing. Page 53. Copy of the charge sheet.
You have a.
It's incomplete.
You have a complete set.
My lord, I have annexed the statement of the witnesses plus, my lord, the CDR. That is only, my lord, the finding of the learned session judge, my lord. So that is why other materials I have not, because it's very huge, my lord, and even the CDR, my lord, is more about 1,000 to 2,000 pages, my lord. For that reason, he has not been annexed, my lord. Because the CDR details, my lord, it has been mentioned at page 51, wherein the accused persons whose numbers have been tracked, my lord, it is clearly mentioned here.
Yes.
From 1 to 16, my lord, there are a number of accused persons whose name has been, my lord, entered, and phone number also has been entered, my lord.
What is this case about?
This is basically, my lord, it is in relating to, my lord, some this Jain Hills district, some coal issue, my lord, some NGOs were assaulted.
It's a case of
My
assault.
lord, yes, my lord. So section 307 also was invoked, and randomly, my lord, whoever were into the business, coal business, were picked up, my lord, and dragged in the case, my lord. That is the case, my lord.
That you see, upon charge sheet being filed.
Yes,
So
lordship.
you see, the IO
Lordship.
must have done his work. Otherwise
It
he
is
would
there,
not
my
have filed a
lord. But in
charge sheet,
yes, absolutely, absolutely, my
implicating
lord.
Eddie, Tom, Dick, or Harry.
Yes, my lord. Here, my lord, what has happened is, when the order was passed, it was passed, my lord, a common order, my lord. The common order was passed, my lord. Applications were filed by the series of accused persons, my lord, and the order was commonly passed, my lord. And it was held, my lord, in the CDR report. Even that also is enough to rope my accused, my lord, in the instant case. That is the finding, my lord. Notice may be issued, my lord.
Lordship, mere absence of CDR, Lordship, cannot be a ground to discharge the accused from the trial, Lordship. And he has been declared as a proclaimed offender.
That is
See what the law says on
absolutely, my lord.
What is admissible, what is not admissible.
Absolutely, my lord.
What can be relied upon by the trial court to frame charge, what cannot be.
Absolutely. Whatever is there on record,
The
only the
trial
court
court,
has to.
Lordship, had passed the order after hearing the accused person, Lordship.
Exactly. That will be taken into account.
Your Lordship, if your
But
Lordship...
you're coming, see, Mr. You're coming by way of a an
482,
application under 482. Perhaps you should have been by revision or appeal.
482, my lord, has power, and I am.
When there is a specific provision
yes, my lord.
against a particular order by a trial court, you cannot come by 482.
482, my lord, does not bar, my lord.
Does not bar.
My
but
submit.
see,
My.
What happens is, you see, it is it becomes an overall cover for everything.
Absolutely.
And anything that that is permissible and not permissible.
Yes, lord.
So that cannot be. When there are specific,
But in this case, my lord, to my humble submissions, this will be applicable. Why, my lord, prima facie, my lord, when my lord goes into the materials placed before the learned trial court,
See,
there is
as
not
far
even
as 488, 482 is concerned, this court will only be concerned with the conduct of the court, whether the order pass was in proper procedure,
lordship.
whether there is any materials which ought not to have been taken into account, and so on and so forth.
Lordship.
We'll have to look into other aspect of the matter apart from the issue of jurisdiction, which would be available only through a revision petition. But that also you have to.
Lordship, notice may be issued, my lord. But I'll satisfy my lord on that aspect also.
How many respondents are there?
No respondents, only state respondents.
Only state, my lord.
You have accepted notice.
I'll accept the notice. And let him also produce the complete case diary, Lordship. Because some more observations of the IO are there. It's incomplete, Lordship. Let him produce the complete copy also.
Either that or you have your copy, you bring your copy. Heard Mr. Espantil, learned counsel for the petitioner. Mr. H. Kharmi, learned. You are still additional PP?
Yes, Lordship.
And additional PP has accepted notice on behalf of the respondent. And as such, no further notice, no further formal notice is required to be issued upon the said respondent. Records are necessary, not done.
No, I think it is the trial, it's under trial. So the court records also may be called. Or will we, if necessary, we'll call, we'll seal it all.
Yes, you will seal it all. Otherwise, you bring photocopies.
Photocopy.
This court would not like to disturb the proceedings.
I'll bring a copy
So we'll post the matter for hearing.
for hearing.
On prayer made by the parties, list this matter for hearing after 2 weeks.
Oh, that's
Item number 5.
My senior counsel is on leave, Your Lordship. My senior counsel is on leave.
Mr. Devnath is on leave.
Yes,
This is the matter contempt with lordship which they have preferred on SLP.
supposed to, what do you not? At least he should have instructed you what to submit. What is this? Because I believe today is only for confirmation of the SLP.
Absolutely, lordship.
Status of the SLP.
Filed, Your Lordship, but it is yet to be listed.
Lordship, what has happened is that they have filed a SLP before the registry. Now the registry has rejected, saying that it is defective. So after it's been defective, they have not yet rectified till date also. So now they've come before this court saying that SLP is pending.
We'll give them one more chance. Mr. R. Devnath, learned CGC, is said to be indisposed and could not appear for this court. Mr. P. Nongri, learned counsel for the petitioner, has submitted that as far as his personal knowledge is concerned, the special leave petition filed by the respondent, Public Union of India, as far as this matter is concerned, has not yet been taken up by the apex court. Be that as it may, the parties would agree that matter. Parties would agree that further confirmation is required to be awaited. Accordingly, matter is now posted after 2 weeks. I think by that time we'll get some.
5 and 10.
We'll try to find out also.
I'll find out.
Bring out the whatever
Your Lordship.
whatever is uploaded, the cost list or this.
Because of that, I found out that they have not yet rectified.
You'll find those information from the net only.
Item 5 and 10 same.
Okay, item 10, as paid for, list this matter after 2 weeks.
Item number 6.
affidavits have not been filed, my lord.
My lord, I appear for the state respondents number 1. My lord, we have received our instruction. We will be able to file before the next date, my lord.
Mr. Uttam, you are appearing
For the petitioner, my lord. I've been newly engaged, my lord. On the last date, I've filed my file.
And my lord, entering parents for number 3, respondent number 3.
and
For 1, my lord. I'm only for number 1.
and who's 2?
My lord, there have been change of counsel. So, my lord, I believe there will be new counsel entering appearance.
Mr. Jindal is appearing for 3. So we look at 2.
Mr. Nongpyo was representing, my lord.
Previously,
Darbar
Mr.
of-
Nongpure was
Nongpure
there, my
was
lord.
representing.
2 and 3.
Mr. Nombi,
ML Nongpyo.
but who is?
My lord, there have been some clash of the clients, my lord. That's why they have withdrawn and new counsel has appeared now.
Or who has appeared? No, but you are appearing for 3, not for
Only
2.
3. So 2 is yet to enter appearance, my lord.
Have you taken fresh steps, Mr. Uttam?
No, my lord, I've not taken fresh steps. I'll have to check the record, my lord, whether service has been completed earlier or not. I believe service has been completed earlier, my lord. The only thing is there's been a change.
Service has
of-
been completed as far
They
as
were represented.
post disengagement of the previous counsel.
Lordship. Obviously, my lord. I think so, my lord. I'll just have to check the record once, my lord. If there has been nobody is appearing, then I'll have to take fresh steps, my lord. Obviously.
Mr. Jindal, you are appearing for the first time.
First step, number 3.
So most probably you've received notice.
My lord, there was some other counsels who
Okay.
who had the week before. So I'm a freshly newly appointed counsel. So somebody else had appeared. I'm not sure exactly who.
Okay.
Somebody else was there for number 3.
So in the same way, you see that would also be applicable to the respondent too.
So previously, the same council was the previous council was representing 2 and 3.
Yes.
Yeah, exactly.
2 was represented by 1 counsel, my lord, but now my friend he is representing only for 3.
You take fresh steps,
I'll take fresh steps, my lord.
Mr. This is Uttam, learned counsel for the petitioner, is present. Ms. Arkulni,
For 1, my lord.
learned G has also appeared on behalf of respondent number 1, public collector. Mr. S. Jindal, learned counsel, has entered appearance on behalf of respondent number 3. None has appeared on behalf of respondent number 2. Accordingly, as prayed for by the learned counsel for the petitioner, fresh steps on the said respondent 2 is allowed to be taken. The same returnable within 2 weeks. This matter thereof.
Obliged.
Item number 7.
Yes.
The Union of India had to file an affidavit in this matter. So Devnath was had sought time.
I pray for more time, my lordship. I pray for some more time.
You appearing for 3 and 4. Have you filed your counter?
Yes, sir.
Except for
Lordship.
enough time has been given to you. Mr. Ardapnad is learned CGC is said to be indisposed on grounds of personal difficulty. However, from the records, it appears that the counter affidavit on behalf of the respondents 1 and 2 represented by Mr. Devnath has not yet filed their counter affidavit. Accordingly, the said respondents are directed to file their counter affidavit on the next date fix. This is matter of 2 weeks.
Highly obliged.
Item number 8.
in this matter, we were required to file objection to the impleadment application that filed, my lord. The objection, my lord, is on the verge of completion. I'm just praying for a week's time. Almost ready, my lord. Just praying for a week's time, my lord. Next week we will file it.
Mr. S. Thakur, counsel for the petitioner has submitted that the petitioner is supposed to file an objection to the application for impleadment filed by on behalf of the respondent number one, deceased respondent number one, could not be filed today. It is prayed that some more time will be allowed for the said objection petition to be filed. On premier, the same is allowed. This is matter up to 1 week.
Item number 18.
May it please your lordship, I'm making a prayer on behalf of Mr. S.N. I pray if the matter can come after 2 weeks, my lord.
He was
I
here.
seek the consent of... He's not ready, my lord. Seems.
You're for?
For a state.
Petitioner?
Yeah.
On pre-made by the petitioner? Seeking accommodation on the ground that you done it. Sorry. On pre-made by petitioner, not objected to by respondent, place this matter after 2 weeks.
All right.
Item number 19.
Lord, in fact, my lord, this matter has rendered infectious, my lord, with the effects of time.
That fishing thing?
My lord,
Yes.
fishery matter, my lord. My lord. Only one observation, my lord, that any settlement, my lord, in future may be as per the law, my lord.
That would, why should, once become infectious, infectious. If you have any fresh course of action, then you file it. Mr. Learned Counsel for the petitioner has submitted that this matter may be disposed of since it has become infructuous. Accordingly, petition is disposed of as infructuous.
Please, Your Lordship, this matter is become infructuous.
This is horrible.
Oh, sorry.
Hello.
Is my voice too low that you cannot hear? See, I agree. My voice I cannot exert myself because I'm having this throat problem.
Yes.
You see, I cough. So I'm having chest. So if I raise my voice, then my voice will crack. Instead of hearing me, you will hurt your ears.
Hello.
Item number 21.
Yes. All the parties are present. Anyway, petitioner can start.
Your Lordship, what has happened here before my learned senior starts? We are challenging the maintainability of the writ petition. So we have filed an affidavit only to the extent challenging the maintainability of the petition, Your Lordship, because here the issues are all disputed question of facts, number one. And number two is that there is an appeal forum also, Your Lordship.
Then it should have been, listed.
Let me start, my lord, because I'm the petitioner, my lord.
Yes, you're the petitioner. His objection is on maintainability.
Your Lordship.
It should have been posted for admission hearing.
No, not admission hearing.
It should have been.
It should have been.
Anyway, this is a 22 matter. So, Mr. Kinjing?
Yes, my lord.
We will stick with the issue of maintainability first.
Yes, if they want that, that's the way to want that. Otherwise, in this case, my lord, they have chosen not to file a counter, my lord. There is only one point, and that is the point of maintainability.
Exactly.
They have chosen that also. Except that private respondent, but the official respondent who are authority, in which I am raised my challenge, they have not filed a counter, my lord.
Because after if I make my submission to Lordship on maintainability, I feel I'm confident that will succeed, Your Lordship. That is why. Because the catena of decisions of this Honorable Court, which I'll place, Your Lordship.
There are orders from this Honorable Court also, and this matter that the maintainability has to be.
Your Lordship. These orders are there.
In fact, my lord, I'm appearing for respondent number 7. And my lord, white order dated 6/3/2023. My lord, I have seek permission to reserve my right to file affidavit in the event the petition is maintainable. So basically, the issue of maintainability will be raised first.
Anyway, as far as that issue is concerned, Mr. Kinjing is not opposing that. We will hear.
Yeah, the only thing is, my lord, they have chosen not to file a counter.
No, because, Your Lordship...
No, whether... No, let me complete. Because in that matter, my lord, because whether the court has permitted them that they need not file a counter, my lord.
This order has... This is as far as Respondent 7 is concerned.
Your Lordship, in my affidavit also I have craved leave. I have already stated the respondent states that this affidavit is filed only to the extent of the maintainability of the writ petition. The respondent craves leave of this Honorable Court to file a detailed affidavit dealing with the merits of the case in the event this Honorable Court holds the writ petition is maintainable.
Whether is that order is that effect?
I've already taken crave leave, Your Lordship. Now, Your Lordship, let's put a situation now. If the writ petition is dismissed, is it required to file in merit? Not required anymore.
No, that remains to be seen. Only...
so we'll hear now only on the maintainability issue. If Your Lordship is convinced...
Mr. has already fast forward his case to presume a situation where if this court decides that this petition is maintainable, then at that point of time you will be precluded from filing counter on merits.
Yes.
That is his stand.
That is his stand.
You might say otherwise.
Yes.
So we'll cross the bridge when we come to it.
But my point is that we have raised all our contention, my lord, in averment, my lord.
Yes.
And those are the point in which to show, to submit that it is maintainable, that this matter is quite illegal, is not done according to law, and it is only the Red Court can determine the matter.
Otherwise, you see, more often than not, courts would also, suggest that the parties file their complete, counter.
Your Lordship.
Matter to be heard, on merits, and the court. It would be up to the court to decide firstly on the issue of maintainability.
Yes.
Yes.
If that issue is decided, then the judgment need not be long.
Lordship.
If not, then it continues.
Yes.
And decide on merits. That would be, I think, a
That
better, better proposition for all the parties concerned.
All cases also usually are done in that line only. Otherwise, when it's maintain, when it is the court said that is maintainability, then by that time again they will counter the.
I've noticed this. You see, I've noticed.
Here, my lord, the principal challenge of the petitioner is the issuance of a land holding certificate in favor of my party. Now, my lord, the district council has basically issued the certificate following their process. Now, it is we, the respondent 4 and 5, who is the seller and the buyer of the land. We are the actual beneficiaries and the only persons who are actually affected by this.
That is a submission on merits.
Yes.
Your Lordship,
Yes, yes.
Your Lordship in that case will not prolong the matter. Will grant us 10 days time. I'll place my affidavit is ready on merit. I'll place it and then we can have a hearing on maintainability and on merits.
Full-fledged hearing then.
Yes.
Even leave be given to.
You can do the same thing, Mr.
Same
Shila.
thing.
All the respondents.
All the respondents.
Only the required respondents to bring on merits.
In superstition of the earlier orders passed.
Yes.
We will put it that this court will allow parties to file their account.
4 and 5, we have filed a complete affidavit. They have filed a
Yes. That we have seen. We are only one who filed.
2 weeks time, I'll file. I'll
But
place it
authority
in
did
2-3
not
days
file.
time. Then we'll hear the entire matter.
When the matter came up for hearing, Mr. P. Nongri, the counsel for the respondent number.
I'm for respondent number 1, 2, 3, and 6.
1, 2, 3, and 6 has submitted that this matter may be preliminarily heard only on the issue of maintainability, since an affidavit to this effect has also been filed. Since an affidavit to this limited effect has also been filed by the said respondent, and leave was craved for an additional affidavit to be filed if so required. Mr. Jeshila, Learned Counsel for the Respondent 7, has also submitted that the issue of maintainability may be heard before the matter is finally heard on merit, if so warranted. To this effect, the order of this court dated 6/3/2023 was pointed out by the said Learned Counsel to show that this court has allowed the respondents number 7 to file his affidavit in the event the issue of maintainability is decided. However, in course of hearing, the parties have agreed, irrespective of earlier orders passed by this court or submission made, that the petition is to be heard on merit in its entirety. To this extent, the said respondent number IT number 213, as well as respondent number 7 has prayed that has submitted that they may be allowed to file their complete affidavit, complete counter affidavit, and that the matter to be heard on merit with the issue of maintainability to be firstly decided by this court.
Roger.
On pyramid, same is allowed. Let the counter affidavit be filed within the next date fix. This is matter to 2 weeks.
Obliged.
Item number 23.
I know, honey. Oh. Have you contacted Mr. Bola?
Your Lordship, Miss, I couldn't contact him. He's not around. I don't even have his number.
You see, what happens in the last order of this court,
Yes.
this was before another bench.
Yes, yes.
And the
It
bench
was
has,
recused. Yes, Your Lordship.
released the matter.
Yes.
So, it would have been proper for the parties to be brought to notice.
Yes, Your
Or
Lordship.
they should have, confirmed from the cause list. None appears for the petitioner. On submission of Ms. Ailuma Leonard GA, appearing for this state respondent, matter is adjourned. This is the same after 2 weeks.
Right, Your Lordship.
So,